Welcome back to the Deep Dive. Today we are wrestling with, well, a really fundamental question of governance. How does a citizen or, a big company actually get paid when the government, the big debtor around, owes them money from a court judgment?
It's absolutely crucial, isn't it? Because accountability, it doesn't mean much if you can't actually enforce it.
Exactly.
And today, we're focusing right in on the legal blueprint for this. The State Liability Act 20 of 1957.
1957, that sounds old.
Well, yes, it was assented to back in the Union era, but don't let the date fool you. It's incredibly current. Our source material, the Act itself, includes updates right up to October 2024.
Wow, okay, so it's constantly being tweaked.
It proves it's still absolutely central to how things work.
So our mission today, for you listening, is to really cut through the legal jargon. We want you to understand the actual steps, the legal process for suing the state when its employees, its servants, get something wrong.
And maybe even more grippingly, what happens after you win. Those pretty intense mechanisms, financial, political, that kick in when the state actually has to pay up.
Right. It's not just about the law, is it? It's about how the system balances making the government pay with, well, keeping the lights on.
Precisely. Balancing accountability with protecting essential public services. It's a fascinating negotiation, really, all written down in this act.
Okay, let's start at the beginning. 1957. This act didn't just pop out of thin air. What was it replacing? What was the legal landscape before this?
Good question. It was actually a pretty major shift. Conceptually, the Act specifically repealed something called the Crown Liabilities Act, 1910.
Crown liabilities. Sounds very British Empire.
Exactly. That older act was steeped in, inherited British common law ideas. The main one being that the Crown, the sovereign, the state, had a kind of immunity or at least special protections against lawsuits.
The king can do no wrong sort of idea.
That's the historical root of it, yes. So the 1957 Act was about consolidating the law, but also modernizing it. It basically said, no, the state is legally accountable. It can be sued in its own right. It got rid of that old shield of sovereign immunity.
Makes sense.
And the preamble, the introduction to the act, it's incredibly direct. It just says its purpose is to consolidate the law relating to the liability of the state in respect of acts of its servants. Simple as that.
That's the core job right there. So it formalizes this idea.
Yeah.
The state is an entity you can take to court.
Correct.
And just a quick administrative point, we should probably note that managing this act, the powers and functions, it now sits with the Minister of Justice and Constitutional Development.
Yes, that's right. That transfer happened fairly recently, June 2024. It really underscores how significant this legislation is seen to be. It needs oversight right at the top within the justice system.
Okay, let's unpack this further then. If I think the state owes me something or has wronged me somehow, what actually makes a claim valid under this act? Section 1 is key here, I gather. We hear this word cognizable.
Right, cognizable. It sounds technical, but it just means capable of being heard by a court, recognizable by the legal system. Yeah. And the core principle the act establishes is parity. It says a claim against the state can be heard if that same claim would be a valid reason to sue a private person in a competent court.
Okay. So you basically treat the state, legally speaking, like a very large company or an individual?
It's essentially, yes. It lowers the barrier. You don't need some special government law to sue. The grounds are standard civil law grounds.
Got it. So what are those grounds?
The Act lays out two main categories, two buckets, if you like. First, contract law. Any claim that arises from a contract lawfully entered into on behalf of the state. Pretty standard stuff. Government doesn't pay its supplier, for instance.
Right. Breach of contract. Simple enough. And the second bucket. This is probably the one that generates more public interest. Wrongs committed by employees.
That's the big one. Section 1 calls it a claim arising out of any wrong committed by any servant of the state acting in his capacity and within the scope of his authority.
Okay, lots to unpack there. Servant in his capacity, scope of authority.
Yeah, right. Servant just means employee. The key is that the state takes responsibility, what lawyers call vicarious liability, for the wrongs its employees commit while doing their jobs.
So like a government driver causing an accident while on duty, or maybe an official making a negligent decision that causes harm.
Exactly, those kinds of things. The employee is the one who did the wrong, but the state, as the employer, is the one you sue and the one who ultimately has to pay the damages. If they were acting within their job's scope, that is.
Okay, so let's say I have a cognizable claim. Now we get into the practicalities, the procedure. And Suing a government department, it sounds like it requires real precision. Who exactly do I name on the court documents? Is it the minister?
Good question. It trips people up. You don't sue the minister in their personal capacity, and you don't sue, like, the Department of Health building. Section 2.1 is very clear. You must cite the executive authority of the relevant department as the nominal defendant or respondent.
Okay, executive authority. What does that mean in plain English?
It's the political head who is accountable to Parliament or the provincial legislature. So for a national department, that's the cabinet minister. For a provincial one, it's the member of the Executive Council, the MEC. They legally represent the department in court.
Right, so you name the minister or MEC on the papers, but then who do you actually hand the summons to? Who gets served?
This is the crucial dual service requirement in Section 2. It forces a kind of double notification. First, you must serve a copy of the court process on the head of the department.
The head of department, so not the minister, but the top civil servant, like the director general.
Exactly. The DG or equivalent, the person actually running the department day to day. You serve them at the department's head office.
Okay, step 1, serve the DG. What's step 2?
Step 2 has a very tight deadline. Within 5 days, just 5 court days of serving the DG, you also have to serve a copy on the relevant state attorney whose office covers the area where the court is located.
5 days. That's not much time. And you have to do both.
Both are mandatory. Miss that 5-day window between serving the DG and serving the state attorney, and your service could be considered invalid. Your whole case could stumble right there.
Wow. Okay, that's the first real pressure point. But the pressure isn't only on the person suing, right? The state attorney is also put on the clock immediately.
Absolutely. The state attorney is the government's lawyer in this. Section 2.3 makes them act fast. As soon as they receive the court papers, they have to do 2 things pretty much straight away.
What are they?
First, they must, without undue delay, send a written request to the head of the department, the DG they just got served, asking for instructions on how to handle the case.
Okay, standard lawyer stuff.
But second, and this is a really important internal accountability step, the state attorney must give the DG legal advice on the merits of the case within just 10 days of receiving those papers.
10 days to give legal advice on whether the government actually has a case or not.
Exactly. It forces an early assessment. The law doesn't just say talk to each other, it demands prompt legal analysis. It's designed to prevent departments from just sitting on a summons for months or years before even thinking about whether to fight it or settle.
Right, let's fast forward. Assume you've gone through the whole process, you've won your case, and the court issues an order sounding in money, basically, an order saying the state owes you X amount. Now, this is where it gets really interesting. Can I just send the sheriff around to the department to collect?
This is where the state gets its first layer of protection. Section 3.1 lays down a critical initial rule. No execution attachment or process can be issued against the state or its property to satisfy a final court order at this stage.
Wait, hold on. I won. The court said they have to pay. Why can't I use the normal debt collection tools? Why can't I attach their bank account or seize assets straight away? That seems, well, unfair.
It definitely feels different from suing a private company. The rationale is about protecting public services. Imagine if creditors could immediately seize police vehicles or hospital beds or school desks. Government functions could grind to a halt.
Okay. I can see the public interest argument there. So if I can't send the sheriff immediately, how do I get paid?
The Act sets up a specific payment pathway. The debt has to be paid from the department's appropriated budget, the money Parliament allocated to it. And Section 3.3 sets another deadline. Payment must be made within 30 days of the court order becoming final.
Okay, 30 days. That seems reasonable. That's the second big clock ticking.
Yep.
But let's be honest, government wheels can turn slowly. What happens if day 31 arrives and the money isn't in my account?
This is where the escalation process kicks in and gets quite dramatic. It pulls in higher powers. If the department fails to pay within 30 days, the judgment creditor, that's you, then serves the final court order on 4 different parties.
4 parties. Who?
You serve it on the executive authority, the minister MSC, the accounting officer, the DG, the state attorney again, and critically on the relevant treasury that's either the national treasury or the provincial treasury, depending on the department.
So now treasury gets formally involved. The people holding the national or provincial purse strings, what's their role?
Treasury now has 14 days from when they are served to step in. Their job, according to Section 3.5, is to make sure the debt is paid, or at least that acceptable arrangements are made with you, the creditor, especially if the department is claiming it doesn't have enough money in its budget. Treasury effectively has to find or authorize the funds.
So the department has 30 days, then Treasury gets involved and has another 14 days. What if Treasury fails? What if, after all that, the debt still isn't paid? Does the state just get away with it?
No. This is the point where that initial shield against execution finally crumbles. It's the sort of nuclear option in the Act. If Treasury fails to ensure payment within its 14 days, Section 3.6 says the court registrar must then issue a writ or warrant of execution.
So the sheriff can be called in eventually. Against what?
Against movable property owned by the state and used by the department concerned. So, yes, potentially desks, chairs, computers, vehicles belonging to that specific department.
Right. The sheriff is finally at the door. But you mentioned earlier the need to protect essential services. Is there anything stopping the sheriff from seizing, say, the only fire engine in town?
Yes, absolutely. There's a vital safeguard built in here. Section 3.7 says the sheriff attaches the property, but they don't immediately remove it for sale. And crucially, the sheriff and the department's accounting officer, the DG, should try to agree on which assets cannot be attached or removed, if doing so would severely disrupt service delivery, threaten life, or put the security of the public at risk.
Okay, so common sense prevails, hopefully. They can't take assets vital for public safety or basic services. But the other assets, the desks and cars, they're attached. How long before they actually get sold off?
The removal and sale can only happen 30 days after the attachment. This gives the state one last window, another 30 days to find the money, perhaps rearrange finances, or maybe even apply to the court to stop the sale if they have very strong grounds.
It's a complex, multi-stage process designed to push the state to pay, but with checks and balances.
Exactly. And there's one more piece we absolutely have to mention, the personal consequences for the officials involved.
Yes, you mentioned the accounting officer, the DG. What happens to them if they just don't follow these payment steps?
Section 3.16 is quite stark. An accounting officer who fails to take the steps required by Section 3 to ensure payment, or fails to follow Treasury instructions about payment, commits financial misconduct as defined in the Public Finance Management Act, the PFMA.
Financial misconduct under the PFMA.
Ah.
It sounds serious.
It is. It can lead to disciplinary action, dismissal, and even potential criminal charges. It means the person in charge of the department's money has a direct, personal, legal incentive to make sure court-ordered debts are paid promptly.
Okay, we've covered the main process. But are there limits? Does this act override everything else when it comes to suing the state? Section 4 talks about savings.
Right, the savings clause. It basically says this act is foundational, but it doesn't wipe out other specific laws that might place conditions on suing the state or limit its liability in certain areas.
Can you give an example?
Sure. Let's say another specific law requires you to give the government 6 months written notice before you can even start a lawsuit about a particular type of claim. The State Liability Act doesn't cancel that requirement. It respects those other procedural hurdles or limitations if they exist in other legislation.
So you still need to check if other laws apply to your specific situation.
Absolutely. This act sets the general framework for liability and enforcement, but doesn't erase specific conditions set elsewhere.
Got it. And finally, just to be crystal clear, let's quickly recap the key players defined in the Act.
Sure. We've mentioned them, but Section 4A formally defines them. The department is a national or provincial department or administration. The relevant treasury is either the national treasury or the specific provincial treasury.
And the crucial one,
the accounting officer. That's the person appointed under the PFMA, usually the director general or equivalent, who is responsible for the department's finances and who bears that significant responsibility for ensuring judgments are paid. Hashtag outro.
Well, this has certainly been a deep dive into the mechanics of government accountability. We started with that basic idea, parity, treating the state like any other defendant. And we followed the trail through those very specific time-bound procedures, serving the right people, the deadlines for the state attorney, the 30-day payment window.
Leading to the Treasury intervention, and only then, if all else fails, the possibility of execution against state assets, but even that has safeguards for public services.
Right. It's a carefully constructed ladder of escalation.
The core takeaway, really, is that the state is legally required to pay its judgment debts. There's a defined process, and it's backed by significant pressure points, including that Treasury oversight and the ultimate threat of asset seizure.
And that fascinating point about personal liability, The accounting officer facing financial misconduct charges under the PFMA if they drop the ball on paying a court order.
Exactly.
Which leads us to a final thought for you to consider. If civil servants, particularly accounting officers, face potentially serious personal consequences for not paying state debts on time, does that threat actually change administrative behavior? Does it foster a culture of greater diligence?
And perhaps looking upstream, what other mechanisms beyond just punishing delays in payment could more effectively minimize the governmental wrongs, the breaches of contract, the negligent acts that lead to these claims in the first place?
Something to mull over. That's all for this deep dive.